last step, and you have still not started reading yet. Okay, you are just making sure that you are going to read the right thing. Make a list of the purposes for which you will use this case from the judiciary exam perspective. Okay, and after that you will start reading. Okay, so I thought, which are the points for which the question could come? So I read, okay, mercy petition, definitely. Death sentence, yeah. Writ jurisdiction, I can write it as an example that, oh, this case was decided in criminal writ jurisdiction, just to show off my knowledge, one extra case. But there's not much on that I can say. Mercy petition, I can write a bit. Death sentence, I can write a bit. Power of judicial review of court on presidential power, yes, I can write on that. Question on curative petition, there's a very tiny fact on it. I I can just observe that, a curative petition was filed by Vinay Sharma and was rejected. That will show my knowledge, but nothing more, right? Now what I'll do, I can take a piece of paper or a flashcard, okay, a small notepad paper, write the name of the case and write these purposes. That goes in my book so that I know this is my preparation. And whenever needed, I'll open my computer file and see, okay, these were the markings, only this part I need to use. That's my first time reading also, and I am doing the groundwork for my, what am I doing the groundwork for? I am doing my groundwork for the revision also. Okay, P is for precedent, R is for respondent, A is for appellant. In general, I called it A because most of the work at Supreme Court and High Court, a lot of that, there will be an appellant, right? Okay, so OPRA. Now we are going to start reading. We have done the planning right now. And exclusion, irrelevant stuff, don't want. Why? Because you're going to have limited time, lots to cover, high competition. So now we read the highlighted parts of the case to find the answers only for these important points that we have said. Mercy petition, death sentence, writ jurisdiction, okay, power of judicial review, nothing else. If you do like that, you will realize that you can read past more than 70%. More than 70% you will not read. Okay, 26 pages may you will only read 3 or 4 pages. Okay. Also, when you read, now I'll tell you how to go about reading also. You will find out, is there substantive law laid down in the opinion part? What I realized after reading it is that most of the times it was about whether this file was presented or not, whether this file was presented or not. And the court just said that when jurisdiction is in a high level authority, they will be exercising it in a proper manner. Okay, so now this was primarily on a factual basis. Okay, other than this principle, there was no other principle. More or less, it was factual. If you came to this conclusion, then you realize that there is not much ratio I can use in the judiciary exam. If I am litigating on a presidential pardon matter, I can use some things here because, then there may be more facts. But in a judiciary exam, I can't use it, right? So there's no new law here, but reference to other cases is there on the theme of mercy petition, right? So now what does it mean? I'll probably not even read that much. I will just see the conclusion and I will write this case to show how I can get an extra edge over others. That's it. Now imagine if I follow this strategy every day for a year or 2 years, I might have a whole list of about 500 to 1,000 cases which are additional. If I use even 20 extra cases in my answers in an exam, I'm going to make it in the competition, right? Now you can further increase the edge you got by tracking the names of the other cases that were cited to identify one observation for the cases like this. Okay, so this now if I want to go on a learning spree, I don't need to read it now for my current edge, but I want to take it a notch higher. So I will say, okay, Devinder Pal Singh Buller versus state that the disposal of mercy petitions under these require consideration of various factors. Okay, Satpal versus state of Haryana and Vikas Chatterjee and Shatrughan Chauhan. What are they saying? The power vested in the president of India. They are giving us a full quote here. This quote I will use, but the quote is not so useful except in the last part because in exam I can't write everything. So this is that they are just reproducing the constitution. The last part is very important. The power of pardon is an executive action, needs to be exercised in the aid of justice and not in its defiance. And it is to be exercised on the aid and advice of Council of Ministers. This is going to be relevant. Now, when I write this, I'm going to say that 4 cases have talked about this power of the Constitution. This is what was said in one case and upheld in Vinay Sharma. End of story. Now I have written 4 more cases, one paragraph from a recent case, and that will make the difference between somebody getting a 5 and somebody getting a 8 or a 9, or I don't know if the examiner may even give 10. Okay, so now if I don't remember any of this, what will I remember? If I don't remember any of this, I'll remember Vinay Sharma, I'll remember 3-judge bench, and Justice Banumati wrote it. And one of the important points, 2 important points I'll remember. If there is power vested in a senior authority like the president, they would have exercised it responsibly. That's what the court said. Second thing they said is that you have to do it on the advice of Council of Ministers. So 2 points I will remember. No, I'll do it better than any commentary, right? When there are 1400 pages, you look online and you track how many judges have written it. How many unique opinions are there? Whose one opinion should I read? Okay. So in judiciary exam, you have to read the binding, the majority leading opinion. That's the most important. Okay. If you are litigating, if you're doing Supreme Court exam, that time you may have to know minority opinions. But in 1400 pages, you use the same method: exclude, 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 because you're not going to write even 2 pages about the whole judgment unless the whole case question is on that judgment. Okay, exclude and find out maybe 3 or 4 pages that are relevant, 5 pages that are relevant. Okay, and that could be anywhere. Just find that first, then you highlight it and you try to write it. You write it in your notebook, and in future you're only going to look at that. You will never open the judgment again.